Hey everyone, imagine this. You're involved in a lawsuit. The trial date is months away, but before you even get there, the lawyers on both sides are filing applications, arguing in court, and submitting legal documents. What's going on? These are interlocutory applications, mini legal battles that happen before the main trial. Today we'll break down what they are, why they matter, and what happens when they are contested. We'll also cover what happens if a party wants to appeal against the judge's decision on an interlocutory application. Now, a civil lawsuit isn't just about one big trial. It's a process that unfolds in different stages, and in between, lawyers often need to get court orders to move things along. An interlocutory application is a request made to the court before the actual trial for an order that helps manage the case. Think of it as a way to settle smaller disputes before the big battle. So why do we have these applications? They help clarify legal issues early on, ensure a fair trial by organizing evidence, protect the rights of both parties, and prevent unnecessary delays. Without them, lawsuits would be messy and inefficient. Let's look at 5 common interlocutory applications in Singapore. Imagine you're suing a company for breach of contract, but they refuse to hand over important emails proving your case. You can file a document production application to force them to disclose those documents. Second example, if your competitor is misusing your company's confidential information, you don't want to wait until the main trial to stop them. You need action now. You can apply for an injunction, a court order to prevent them from continuing to misuse your confidential information pending the outcome of the main trial. Third example, what if the claimant's lawsuit, the person who is suing you, is completely baseless? That means there's no legal basis. Well, you can file an application to strike out their case, arguing that it has no legal basis and should be dismissed without a need for a trial which will waste everyone's time. To successfully strike out a claim, it should be plain and obvious, just based on the facts in the claimant's statement of claim, that his claim will fail. Fourth example of an interlocutory application. If you sue someone and you have overwhelming evidence that the defendant, the other side, has no real defense to your claim, you can apply to the court for summary judgment, which is essentially a shortcut to winning the case without a full trial. Next common example of an interlocutory application. Courts work with strict deadlines, but sometimes parties may need more time to file their documents. In such cases, they can apply for an extension of time, explaining why they need it. Interlocutory applications in Singapore must be made by way of a summons, that is the application, and a supporting affidavit. A supporting affidavit is a sworn statement by the applicant setting out the facts that the applicant is relying on, along with any supporting exhibits such as photograph, WhatsApp messages, emails, or contracts or invoices. This affidavit is crucial. It tells the court why the application is necessary. Not all interlocutory applications are straightforward. Some are contested, meaning that the other party in the lawsuit strongly disagrees and wants to fight back. For example, an injunction application is often contested because the applicant wants to stop the other party from doing something, but the respondent argues there's no legal basis. A striking out application is contested when one side says the case is baseless, but the other side argues that they have a valid claim. A summary judgment application is also contested because the claimant will insist that there's no need for a trial because the defendant has no real defense, while the defendant will argue that he deserves a chance to present his case in full at trial. If an interlocutory application is contested, the other party, known as the respondent, must file an affidavit in reply, explaining why the application should not be granted. The respondent will also provide their own evidence to counter the applicant's claims. After that, both sides will have to prepare written submissions accompanied by the bundle of authorities. Written submissions are legal arguments put on paper. They explain to the court why the applicant or the respondent should win the application. The written submissions will also cite previous court cases and legal principles and help the judge to understand the issues before the hearing. A bundle of authorities is a collection of legal cases, textbooks, and laws, statutes that support a party's arguments. Judges will refer to the cases in the bundle of authorities to determine the correct legal principles to apply. Once the documents are filed, there will typically be a half-day court hearing where both sides make oral arguments before the judge. The judge may ask questions to clarify the issues, and after hearing both parties, the judge will then make a decision. The judge has two options. The first is to grant the application, meaning that the applicant, the person who made the application, wins, and the respondent must comply with the order. The respondent usually has to pay part of the applicant's legal costs if the applicant wins. The second option for the judge is to dismiss the application, meaning that the respondent wins by successfully resisting the application, and the applicant must pay the respondent's legal costs for the application. After deciding on the application whether to grant or to dismiss, the judge will then ask both lawyers for their views on legal costs. Each lawyer will propose how much the loser should pay the winner, considering the length of the affidavits, the depth of the written submissions, the complexity of the issues, the number of cases cited in the bundle of authorities. The judge then decides the final amount the losing party must pay to the winning party for that interlocutory application. What if one party disagrees with the judge's decision on an interlocutory application? Well, they may appeal against the decision, but there are strict rules. Some interlocutory orders can be appealed immediately, while others require permission from the court before an appeal can be filed. The appeal must be filed within a strict time frame, usually 14 days, from the date of the order. The appeal is usually heard by a higher court, such as the High Court or the Court of Appeal, depending on the case. In an appeal, the party who appeals, known as the appellant, must file a notice of appeal. Both parties will then have to submit fresh written submissions explaining why the decision should be upheld or overturned. A judge or a panel of judges will hear the arguments and make a ruling. If the appeal succeeds, the original decision below is overturned, and the appellant usually wins costs. If the appeal is dismissed, the original decision stands, and the appellant pays costs to the other side. Interlocutory applications are mini legal battles that happen before the main trial. They keep lawsuits organized and ensure fairness. And if you disagree with the judge's decision, you can appeal, but only if the law allows it. Thanks for joining me in this discussion on interlocutory applications. Don't forget to like, share, subscribe. I'll see you in the next video.